Welcome back to John's Briefs, everyone. Here again with Mark Victor from Attorneys for Freedom. I just want to say, Mark, how much I appreciate you coming on the channel. And I mean, you're a man of high standing in the community, so you being willing to give our fans this means a lot to me, man.
Well, I'm sort of a criminal defense junkie, right? I mean, I actually enjoy talking about this stuff. And I really like sitting down with other people who understand the justice system and having discussions like, how can we tweak it and make it better? You know, I don't know if you're aware, I'm now a licensed attorney in Hawaii.
Hawaii as well.
And they have
Congrats on passing the bar in Hawaii.
Thank you very much. And after 25 years of practicing, too. But you know, they have some little differences in their rules and in their procedure, and some things I've already noticed and said, this is a great idea. We should do this in Arizona. Other states should do this. It's really nice to get kind of a comparison of different systems. But yeah, I'm a junkie with this stuff, so I'm happy to talk about it.
So last time we talked about that very brief, we got arrested, you know, after defensive use of force, and we had to go before the judge and figure out an attorney and get the ball rolling. Okay, so now we're going to talk from there to the next step. So the next step, I think, is the first step ended up being scary. I think the next step is scarier still. Today's video is brought to us by the generosity of Firearms Legal Protection. Firearms Legal Protection is a legal defense program for lawful gun owners. You win the fight, and they will help you win the fight after the fight for the rest of your life. There's a link in the description for a coupon code for a discount for all active self-protection watchers. So, all right, I got home that day, right? So we got home that night, let's just say whatever. And now I think the real fight begins, huh?
You're in a big fight.
Because you're not going to go to work the next day.
It's going to be a big... Let me just explain how your life is going to go at this point. When you wake up in the morning, you're going to think about this first thing. And when you go to bed at night, it's going to be the last thing on your mind. And you're going to spend more time in the bathroom. And the things that you like doing, like spending time with your kids, are going to have a black cloud over it, because this is going to run your life. And when I say this, what I'm talking about really is a felony charge. Okay?
Right.
Because when we're talking about firearms, if you get charged with something, it's very likely going to be a felony charge.
Yeah, it almost never is going to be a misdemeanor at this point.
Let's talk about
aggravated assault or whatever
for a moment.
Sure.
What's the difference between a misdemeanor and a felony? It's really a function of how long can you be put in a cage as a result of this. If you could be put in a cage for a year or more, usually you're talking about a felony.
Right.
Year or less, you're usually talking about a misdemeanor. And the protections are different for each. So let's talk felony for a moment. First thing that's going to be coming up on the horizon is probably some variety of a probable cause hearing. This is one of those really nice protections that you get in a free society. Now, all the criminal defense lawyers listening to this are snickering right now, because they know what I know, which is, let me say what some criminal defense lawyers might say about this: rubber stamp. They're going to say, Mark, this is a rubber stamp. It probable cause is easy to find. They find it. It's like a job on the Flintstones.
Okay,
right? Probable cause found, boom. Probable cause found, boom.
Moving forward.
Moving forward from that, there are a couple of varieties of how you get probable cause. One normally is a preliminary hearing. This is a judge hearing where you come on in and the state puts up their evidence. Hearsay is admissible, which is different from a trial. So a police officer could get up on the stand and say, yes, I'm Officer Bob. I don't know anything about the case, but I spoke to Officer Bill, and Officer Bill told me the following things. That usually comes in a preliminary hearing. And remember, the judge's job is not to determine are you actually guilty or not guilty. The judge's job is to just determine, is there enough evidence here to push you through the system.
Move forward.
The answer is no, then you're out of the system. Doesn't mean they can't recharge it and rebring it again and keep trying and trying, but at least for the moment, you're out. The other possibility that's very popular across the country is the grand jury. We've all heard about the grand jury. I'm not a big fan of the grand jury. This is sort of, it's plucked out of the adversarial system, and it's more as part of what we call an inquisitorial system. What that means is when the grand jury meets, they meet in secret. You don't get to go there. You don't get to listen to what's going on. You don't get to present evidence. There's not even a judge there. You know who's running the show? The prosecutor.
Oh, geez.
You get a prosecutor, usually a cop, a court reporter, and then, depending on how the jurisdiction, maybe roughly 12 members of the grand jury. They're just citizens. And their job is to listen to this very one-sided presentation of the evidence, and then they decide if there's probable cause. And if they think there is, they issue something called an indictment. That's sort of a name to flag what would otherwise be called a complaint, but it lets us know it came from the grand jury. Why do we care about that? Because it lets us know we're on the other side of that probable cause hearing now.
Right.
So normally when you roll out of the grand jury with an indictment, you're going directly to your arraignment in the higher court, where you're going to plead guilty or not guilty to the felony charge. They've already found probable cause.
Well, let's back up a minute though, Mark, because, okay, so you're not going to show up to this probable cause hearing and meet your attorney there for the first time.
Well, remember, if it's a preliminary hearing, you get a lawyer there. If it's a grand jury, it happens without your knowledge. You have no right to go. You don't get to liquid.
Right.
Either of
But
us.
I mean, so I'm going to say if I called you at 2:00 in the morning because I had somebody break into my house and I had to shoot him and I end up getting arrested for it for some reason, and I call and you come down to the court and, you know, to the jail, and we have a bond hearing and the judge says, okay, fine, here's your bond, whatever. Well, you and I are probably meeting the next day.
Oh, without a doubt. We're not going to have a, let me just tell you how this meeting's going to go at the jail, right? They're going to put us in the corner somewhere. And there could be guys roaming all over the place. And I'm going to be holding a yellow, because they don't, when they build these jails, they don't really think about the defense attorney very much. We're going to be sitting in a corner and I'm going to be whispering to you and you're going to be whispering to me. And I'm going to be getting the rough facts. I don't care at the moment about defending the case. I'm trying to get you a rear end out of a cage.
Right.
So I'm more interested in the things we talked about earlier in the last video.
Right.
Danger to the community and flight risk. We're not going through the whole case. We're trying to get you past what I call phase one. Once you're out, then we're going to schedule a couple hours at the office, because you're going to need a couple of days to de-stress from this whole incident.
For sure.
Yeah. And then you're going to come in, we're going to sit down and say, okay, let's start from the beginning, and we're going to baby step through the whole incident. So then we can get a good understanding. But even then, because we know we're going to be fighting about the facts, what we're moving into now is you might think of as the discovery phase of the case. What that means is, and different jurisdictions have different rules. For example, in Arizona here, you get to interview all of the witnesses in the case with the exception of the victim, who you could interview if they agree to the interview, but usually they don't. I wonder how the prosecutors present the request to them. You know, the defense attorney would love to interview you. I recommend you don't do it. You don't have to do it. You shouldn't do it, whatever, who knows. But so normally you don't get to interview that person, but you get to interview everybody else. That's very nice if you're a defense attorney. In the federal system, you don't get any interviews. It's mostly trial by ambush. Statements are disclosed. They could be disclosed right before the witness testifies at trial.
Wow.
So it can be very different atmosphere. I tend to like the more open discovery rules. So there's that. Then there are witness statements. Then there are all of the, the audio evidence, any video evidence, fingerprints, blood, those kinds of things. And it'll take several months to tear through all of that, right? Because to the extent that the government gives us the results of tests, let's just say they took a blood test and the blood test comes back and it shows you got something in your system that they think is interesting. We don't have to accept, nor would we accept, their analysis. That's a piece of paper. Anybody can generate a piece of paper. So we'll say, well, we want a sample of the same blood. The chain of custody needs to be solid so we know it came out of your arm. And then we want our expert to review the blood and take a look at it and see what they conclude, because we're entitled to that.
So we're talking here, though, I mean, we're meeting in your office to talk about the facts. We're doing interviews with witnesses. We're talking about hiring experts. We're spending crazy amounts of money right now.
And of course, there are, we're painting this with a very broad brush.
Of course,
right?
because we don't have a particular case.
We don't have a particular case. But in the case of guns, you're talking about ballistics guys, maybe. I mean, of course, it depends on the defense, right? But you could be talking about ballistics guys. You could be talking about all kinds of sort of scientific evidence that you could bring in. None of these people work for free. They all want, fees, reasonably so, to do their work.
Sure, of course.
So, but
and somebody's paying for all those, and that's the defendant.
And you're fighting for your life. It's the most important thing going on in your life at that moment. So there's a long discovery phase that goes on. After that, normally you'll get into what I would call the motions phase, right? So now we know what the evidence is. Common motions in a criminal case are things like suppression motions, right? We might say something about the way the evidence was gathered was, in essence, unreasonable, because that's what the Fourth Amendment protects. Your right to be protected against unreasonable searches and seizures. So we may allege that, hey, this evidence, well, very good for the state, was gathered in an unreasonable kind of a way, therefore it violates the Fourth Amendment, and we want it suppressed, because under exclusionary rule concepts, which come out of cases called Mapp versus Ohio. The Supreme Court decided if they do gather things that are unreasonable, that the state doesn't get to benefit from that. They can't use the evidence. And if the case can't be prosecuted as a result, then oh well.
Then that's why we have a presumption of innocence.
So you can see why motion practice is very important for criminal defense attorneys. Also, that grand jury proceeding we talked about earlier. And in some jurisdictions, it's very easy to get the transcript. Remember I said there was a court reporter in there? In some jurisdictions, like Maricopa County, it's a big pain in the neck. We have to jump through all these hoops, and there's off-site locations, and there's this and that. It's a big, giant process. But we get them in every case because in there can be lots of important information. What you can't do with these grand juries is argue that they came to the wrong decision. They just say, look, you don't get, that's what a trial's for.
Right.
What you can do, depending on the jurisdiction, is to say something about the way the case was presented, it violated due process. Imagine a prosecutor in this sort of closed, quiet setting says, oh, we're investigating this fellow. Oh, he's a real jerk. He's got a whole bunch of felony priors. He cheats on his wife. I'm sure what he did was a horrible thing. Now let's talk about the facts.
Right.
That would
just
obviously
prejudice
be
the case. Yeah.
a very biased presentation. Right. The other thing is, and especially in a self-defense case, what if they presented the facts and then they failed to give the proper self-defense instructions? Like, for example, in Arizona, we have 13411, sort of an off-the-wall, weird crime prevention statute. Well, if they only give the standard, maybe deadly force self-defense instruction, and they don't bother telling anybody about 13411, then we might say, hey, my guy didn't get a fair shake. They should send it back and do it again. We've won several of those over the years.
Okay. That's an interesting bit. So once we've done through all these motions and they get done, and again, I'm sure we're meeting several times during this time. I'm taking days off work during this time.
No question.
I'm spending, again, crazy amounts of money mortgaging the house and taking all the money out of the 401k at this point. So I think at this point, man, this to me seems like the process is the punishment.
I've written some articles about this before. I have an article, Not Guilty on 83 Pounds and Still No Justice. I had a woman who had 83 pounds of marijuana on board, and we went to trial, and I got a not guilty. And it was great, but it sure didn't feel to her like the presumed innocent, exactly what you're talking about. And I could see the punishment. Going through a jury trial, what an ordeal. Imagine for a moment standing up and having a jury come back, knowing that if they say guilty, you're going into custody for many years. If they say not guilty, you're walking out. Think about the pressure on this for a moment.
Yeah. Well, that's what we're going to talk about next week, guys. We're going to talk about the trial. Mark, this is fascinating to me. Thank you.